Thank you all very much for joining us today for our presentation on the EB-2 National Interest Waiver. My name is Dustin Saldarriaga, and I'm a Senior Associate with Scott Legal PC here in New York City. And joining me today will be my colleague, Jiyae Hwang, who is also a Senior Associate and has extensive experience preparing EB-2 National Interest Waivers. Now, this is a uniquely popular category of green cards because, first of all, it allows for entrepreneurs to self-petition so that they don't actually need a third party to petition for them. They can petition for themselves. And also, it tends to be a great option for people who are in the US on a visa like an E-2 treaty investor visa. If someone in that status, which is a non-immigrant status, wants to then transition to a green card to pursue permanent resident status. So a few housekeeping items before we get started. If you do have questions, feel free to send them in through either the chat function or the Q&A function on Zoom. After this presentation, we will be sending you an email with a few things. First of all, it will have the PowerPoint presentation that you see on your screen. We'll also send you a comprehensive guide to the National Interest Waiver with kind of the best information we have on the visa, and we hope that's helpful for you all. It goes into a bit more detail than we will get into in this presentation. We'll also send a link to our YouTube channel where we post our full-length webinars. This webinar is being recorded, and we also post shorter videos on a variety of immigration topics. And we will also send you a link where you can sign up for future webinars. We try to do at least 2 a month, and right now I think we're doing about 2 a week. And those also span the full spectrum of US immigration law. And on that note, I did want to mention that even though we do focus on business immigration, including the EB-2 NIW, we are a full-service immigration firm. So we handle family immigration, humanitarian immigration, and really anything in between. So we hope that you'll reach out to us if we can be of any help at all. Without further ado, I will go ahead and pass it off to Jiyae.
Thank you so much, Dustin, and thanks everybody for joining us today. I'm happy to present about the NIW. So let's get started and start with the basic requirements for the National Interest Waiver. And the NIW, right, is a subset of the EB-2 employment-based immigrant petition. And immigrant petition means this is an application for a green card for a U.S. permanent resident status, right? And as you may all know, a green card gives somebody the ability to live permanently in the United States and work for any employer or not at all. So having a green card opens up also the possibility and pathway to U.S. citizenship down the road. And as Dustin mentioned a bit earlier, EB-2 NIW is a popular choice among individuals who want to apply for a green card on their own, and this is called self-petitioning. So you can apply for the green card as an individual, whereas normally you would need a U.S. company to sponsor you for a green card. EB-1A, the extraordinary ability petition, is another category that allows self-petitioning. However, that is not an option that is available for a vast majority of people. So the EB-2 NIW can be a viable option for a wide variety of professionals who can show that their work will make significant contributions to the industry or society or U.S. interests as a whole. So let's talk about the eligibility criteria for an EB-2 NIW green card petition. So the first requirement is that you must meet the EB-2 threshold. The threshold requirement for qualifying under the EB-2 criteria, employment-based criteria for immigrant petition. And really, this can be met in 2 ways. The first way is to show that you have an advanced degree, which means a master's degree or a higher level degree, right? And for example, an MBA. If you have an MBA, that also counts as a master's degree. If you have also a degree like a JD, a Juris Doctor, or an MD, a medical doctor degree, that can also count as an advanced degree because you need to have a bachelor's in order to gain admission for those types of programs. Now, there is another way you can meet the advanced degree threshold by having what is called the equivalent of a master's degree, which is if you have a bachelor's degree in your field, and if you have 5 or more years of progressive work experience in your field following your attainment of your bachelor's degree, that can also count as an equivalent of a master's degree in that field. Now, though, what does it mean to have progressive work experience? This means your job duties and your responsibilities have grown in complexity and seniority over time. So if you've stayed in the same position for the 5 years that you're trying to claim for progressive work experience, that will not work, unfortunately. You do need to have that progression in your career in order to use that experience to meet the equivalency for a master's degree. Now, let's say you don't have a master's degree, you also don't have a bachelor's degree, or you don't have that 5 years of work experience. There is another way you could qualify under the EB-2 category, and that is by showing that you are an individual of exceptional ability. Now, exceptional ability is very different from extraordinary ability, which is a standard used in the other type of self-petitioning for a green card, the EB-1A. That is very different than the exceptional ability. It is a much lower standard to meet. Now, in order to show exceptional ability, you need to be able to provide evidence corresponding to at least 3 out of the 7 enumerated evidences that is listed below. So that includes, for example, 10 years of full-time experience in your field, a related degree in, for your field of expertise, and it can be any degree. It can be an associate's degree, it can be any diploma. If you have a related license to practice in your field, that is also another type of evidence that they're looking for. If you have a membership in professional associations, the important thing is to show that you have earned recognition in the field, right? So for example, if you have won any awards, if you have published any papers, patents, or done anything that can be considered a significant achievement in your field and have earned recognition for that. They would want to see that kind of evidence to show, really to holistically show that you are someone who is operating at a level substantially above what is ordinarily encountered in the field, because that is the standard for exceptional ability. For example, high salary can also help prove that. So just ask yourself the question, does the universe of evidence that you have meet 3 out of the 7 criteria first? And also, cumulatively, does the evidence show that you do have a degree of expertise that is significantly above that is ordinarily encountered in the sciences, arts, or business? And if the evidence shows that, then you can certainly try to meet the EB-2 threshold through exceptional ability. However, if you do already have an advanced degree, that is the most straightforward way you can meet the EB-2 threshold, and you don't even need to go through the exceptional ability analysis if you already have the advanced degree. Now, let's say you can show that you meet the threshold criteria. The other part of the NIW petition is to support your eligibility under the 3-prong matter of Danaher test, right? So the matter of Danaher test requires that you show, basically you can persuade the USCIS officer that you meet the 3 criteria outlined below, which is first, that your proposed endeavor in the United States has substantial merit and national importance. Second criteria is that you yourself are well positioned to advance the proposed endeavor that has substantial merit and national importance. And the third criteria is that there must be a showing that on balance, it would be beneficial for the United States to exempt you from the requirements of a job offer and a labor certification. So let's get a little bit more in detail about that. The first criteria, substantial merit and national importance. Now, what does that really mean, right? So substantial merit can be shown in a range of fields. It can be, the arts, sciences, business, even culture, even, artistic endeavors can, be shown to have substantial merit. Now, the challenge is to show that your work has national importance. And what does it mean to have national importance, right? So it really means that your work does not only benefit your immediate clients or your immediate employer if you're being hired by someone, right? Your work should have national or global implications in a particular field by, for example, providing some sort of innovation in the way that things are done in the field, by, helping, technology advance, or by providing innovations in an area that is important to U.S. government, such as cybersecurity or aviation or AI technology or things like that. So some of the examples that the government uses in talking about global implications is medical advances or improved manufacturing processes, right? So if you're in the field of developing a new innovation to improve best practices in those kinds of areas that is important for the United States, then you would have a good case to meet the national importance criteria. Now, let's talk a little bit about the second criteria, that you yourself are well positioned to advance the endeavor. And for this prong, the government will look at the applicant's education, experience, and really to see if they have a record of success in similar or related endeavors that will position them well to, drive the endeavor to success, so to speak. And the third requirement, on balance, there must be a showing that it would be beneficial to the United States to waive the labor certification requirement. Really, what they're looking for is, can you show that the benefits of your proposed work in the United States will be broad enough to outweigh the ordinary benefits of the labor certification process, which is to protect a job for a U.S. worker as opposed to giving it to a foreign national, right? The ordinary benefits of having the labor certification is protecting the U.S. job market. An interesting point to note, which is not always evident, is that you do need to meet all three criteria to qualify for an NIW. So even if you're well positioned to advance an endeavor, even if on balance it would be beneficial, if for example, you fail the first prong, that your work does not stand to benefit, the economy or the national interest on a broader scale to meet the national importance criteria, then unfortunately the NIW argument will fail. So all three criteria must be met in order for the NIW petition to be approved. All right, now we can move on to the next slide. How can the National Interest Waiver be used for entrepreneurs? So just a few changes to the case law has made the NIW, EB-2 NIW a favorable category for entrepreneurs to, apply for a green card under, right? So what happened with the new matter of Denisar case law is that it changed the criteria of which with which the government will judge national importance. So the previous case law really focused on the geographic scope of your endeavor and was really asking, does your endeavor touch all of the states, right? Can you, or as opposed to being, limited to a particular region or a particular state, right? However, with the new, case law that came down with matter of Denisar, the government explicitly moved away from that geographic focus, right? So even if your business is limited to one particular state or one particular region, if you can show that that work in itself has a broader impact, right, to on a global scale, on a national scale, in terms of improving best practices for your field as a whole, right, in terms of a qualitative way. Or if, for example, if your endeavor is developing a particular underprivileged region that is a priority area to develop economically for the U.S. government, even if the impact is limited to that particular region, your endeavor can certainly be found to have national importance, regardless of the geographic scope of your endeavor. So that is definitely a positive change that happened that would make the NIW more accessible to a wider variety of entrepreneurs. The second point to make is that the case law explicitly recognizes that entrepreneurs are self-employed, and so they're often not eligible for other alternative pathways to green card process. So it can be an advantage in terms of the arguments that you can make by saying that, hey, I'm doing this great work in the United States, but I do not have an alternative to get a green card because I cannot get a US-based sponsor to go through the labor certification process for me. Because if you're self-employed, or if you own a majority stake in a US business because you're an entrepreneur, you likely cannot proceed with the ordinary process of labor certification with using that U.S. company as a vehicle. And the reason why is because you do have that ownership in the company. So we can use that, entrepreneurs can use that fact to their advantage when they're talking about the relative benefits on balance that it is beneficial to the United States to exempt you from that process because it is impractical for entrepreneurs to use that. Now, the third point to make here is that the new standard with the matter of Danisar case specifically notes that entrepreneurial work can lead to an NIW and states that the planned venture does not even need to be ultimately successful as long as the applicant can show that there is a plausible basis for that business to achieve that success. All right, so now let's shift gears a little bit and think about some of the practical considerations when you're considering applying for a green card under NIW. So timing, how long does it take to get an approval for the NIW and to get the green card? So it is important to note here that the green card application has two steps, right? So the first step is the underlying petition. In this case is the I-140, which determines if you are eligible for a green card under this category. And the second step is the actual application for a green card, which can either take the form of an I-485, an adjustment of status application if you're already in the United States on a different non-immigrant status, or you can also apply for an immigrant visa through your home country consulate, right? This means you would file what is called a DS-260, and you would go to your home country consulate to attend the immigrant visa interview. And if you're approved for that, you would get an immigrant visa stamp in your passport, and you would enter the United States and land as a permanent resident of the United States. So those are the two different ways you can process the second step, the application for a green card. So let's talk about the timing for both steps. So the first step, the I-140, premium processing is available for NIW applications. And the processing time standard is 45 calendar days. So what does this mean? So after you file your I-140 petition under the EB-2 NIW category, an action will be rendered within 45 days. This could be a decision. This could be a request for evidence. This could be a notice of intent to deny even. But the government is basically promising that they will take some action within 45 days. Of course, this could also be a straight approval, right? And it could also be shorter than 45 days. And we have seen actually cases where we would get an answer, we would get an approval actually within like a week, within a few weeks, within a month. We've seen cases run the gamut, but we have seen cases being decisions being rendered quite quickly, and it does not have to be at the end of the 45-day period. The government can give you the decision sooner than that. If you don't use premium processing, then it usually takes about a year for the underlying I-140 to be processed. One thing to note is that if you are on a non-immigrant visa category that does not allow dual intent, and this includes TN visas, this includes E2 statuses, this does not technically allow for dual intent. So, and once you file the I-140 NIW application, right, it is an immigrant petition that you're filing, and it is very important to recognize that. So once you file the I-140, it does pose some degree of risk for you in extending or renewing any non-immigrant visa categories that do not allow dual intent. And the TN visa is a good example of that. If you are Canadian and if you're on a TN visa, and if you filed an I-140, the next time you need to renew your TN visa at the border, it is possible that you will get a lot of pushback from the officers regarding non-immigrant intent because you have an I-140 filed. Even if the I-140 is pending, even if the I-140 has been denied, it could give you some difficulties. So it is very important to think about this timing and the strategy on when you would apply for your NIW. What is the application process? So as I mentioned before, the first step is to submit the form I-140, the underlying petition for an immigrant immigrant visa, immigrant status, with proof that you meet the EB-2 qualifications and proof that you meet the three-prong criteria, matter of Dennis-R criteria to merit an NIW. If there is an immigrant visa available, which means the priority dates are current for that category for your country of origin, you may be able to concurrently file the I-485, which is the adjustment of status petition for you to, obtain permanent resident status based on the I-140. However, since November 2022, the priority dates have not been current. So this is really a new development. The NIW EB-2 criteria has always been current for the past decade. However, since November 2022, because there are less visas available than there are applications for the visas in that particular category for most countries around the world, the priority dates are now backlogged, which just means you need to first go ahead and file the I-140. And based on that approval, you will file at a later time your I-485 or apply for an immigrant visa. There'll just be a waiting period until your priority dates are current before you can do so. And right now, we've been seeing an average wait time of about a year after you file the petition until to when you can file. So definitely consult with us if you'd like more detail on what are the expected timings given the backlogs at present. Now, this could change, right? And priority dates do fluctuate over time. So if you're already in the United States on a different status, definitely it would be good to have a good idea of how long the NIW process would take before starting this process. Pros and cons of adjusting status in the United States versus consular processing. So the advantage of adjusting status from within the United States is that it allows applicants to continue living in the United States in the interim while the I-485 is processing. So, and it is important to know that you can only file the I-485 adjustment of status application if you're already in the United States on a different non-immigrant visa status. For example, if you're already in the United States on an E-2 status, and if your priority date is current at that time, you can apply for an I-485. However, it is very important to note that you cannot file the I-485 before your priority dates are current. So it is possible that your status may be running out, but your priority date is still not current, then unfortunately you need to extend the status before you can file, or you need to leave the United States and choose, the consular processing option if that's the case. It is very important that you that both your priority dates are current and also you are in the United States on a valid non-immigrant status. Now, a common misconception. Filing the I-140 itself does not give you any independent basis to extend your stay in the United States, right? So, and it is a common question that I get from clients. You can only continue to remain in the United States after you are able to file the I-485. So filing the I-140 does not give you the ability to extend your authorized stay. Filing the I-485 does. So that is a key distinction that you should keep in mind. Now, one major disadvantage of adjusting status from within the United States is that it restricts your ability to travel outside the United States while the I-485 is pending. So once you file the I-485, what you can do is you can file for an I-131, which is application for advanced parole. And once you have the advanced parole, you could use the advanced parole to travel outside of the United States and come back in without abandoning the application. But that can take some time to get approved. It can take 6 months to about a year for you to get approved for the I-131. So there could be a period of time after you file the I-485 where you are basically stuck in the United States and you cannot travel abroad without abandoning the application. So definitely that could be one reason for someone to choose consular processing as an alternative, which is, filing the DS-260 and, attending the immigrant visa interview at your home country consulate. That is another option you can take. For some people who need to travel back and forth, that could be a better option. One disadvantage of consular processing is that it does not give any independent basis for you to continue staying in the United States, right? And it could be difficult to renew or extend certain visa statuses after you file the I-140. So it may be that you are stuck outside the United States for a certain period of time before you are approved for the immigrant visa, and you can come back into the United States as a permanent resident. So it really depends on the person's particular preferences on where they would like to stay while the process is ongoing.
Great, Gia. We got a question about the pros and cons of consular processing. If someone has a B1, B2 visa and applies for consular processing and their application's denied, does that affect their B1, B2 visa?
So just the fact that you have applied for an immigrant petition would not automatically cancel your B1, B2 visa. However, it will likely give you a lot of difficulty when you try to renew your B1, B2 visa because you have because you have expressed immigrant intent through filing the I-140 petition.
Great, thank you.
Okay, so we will move on to the next topic, which is updated guidelines for STEM and entrepreneurs that came down in 2022. So let's talk a little bit about what has changed in the way that the government adjudicates cases that relate to STEM, which is science, technology, engineering, mathematics, or cases pertaining to entrepreneurs. So the government has published specific guidelines for both categories of cases, which would be worth it to go over. So the important update about STEM-related cases is that now there is a critical and emerging technologies list, which is very advantageous if your particular endeavor is related to developing advancements to those technologies. We have a list that the government has published that confirms that those technologies are important to U.S. security interests, important to U.S. national priorities. So what are these technologies? I can read you some of the technologies that are in the list, including, for example, advanced computing, advanced engineering materials, advanced manufacturing technologies, advanced sensing technologies, aero engine technologies, agricultural technologies, artificial intelligence, autonomous systems, biotechnologies, communications and networking technologies like 5G networking technologies, for example, data science and data storage, data processing technologies, distributed ledger technologies, energy technologies, medical and public health technologies, quantum science, semiconductors, and space technologies are some of the areas in the CNET list. So if you have an advanced degree in STEM, and if your proposed endeavor has something to do with, developing advancements to those technologies, you would have a strong argument to meet national importance for that. There are also specific guidelines pertaining to entrepreneur applicants. And the important thing to note is that entrepreneurs are now able to prove some of the matter of DANISR criteria with non-traditional forms of evidence. So, for example, substantial merit or national importance can be now supported by, business-specific evidences such as grants received from government entities, letters from third parties such as venture capital firms, for example, like industry actors. So you can see that it is different from the typical PhD, researcher profile, right? But the government has recognized that in the business field, you could have non-traditional forms of evidence that could support merit. So, for example, if your business has been accepted to a prestigious accelerator or an incubator, that in itself can also support national importance by showing that the groundbreaking potential of your business idea has been independently verified by those prestigious accelerator or incubator programs, right? So that those types of evidences can be used for the NIW petition. Also, if you have evidence of revenue generation and strong, business growth, and if you have a history of strong, U.S. hiring. So if you have tax returns or forms W-2 that shows that you have dozens of employees under your business, and if you can show a growth of revenues and a high valuation, for example, for your business, that can also support the argument that your continued work would have a substantial positive impact to the U.S., industry and economy. So that can also be a favorable form of evidence for entrepreneurs. Well-positioned can also be supported by lots of different forms of evidence. So an entrepreneur can provide proof that they have majority ownership over that business entity and show their critical role in the U.S. entity to show that they are well-positioned to continue driving forward the U.S. business. Letters, evidence of investment interest from third-party investors, such as venture capital funders, for example, that could be helpful. You could also get a letter from an incubator or accelerator confirming why you as a founder, why you as an executive are well positioned to drive forward the business project to its success. If you have authored intellectual property, even if the intellectual property is owned by the company. So even if your name is not in the patent, for example, if it is a patent that the company owns, you could also use that to support, the merits of your endeavor and the potential to, provide innovations to the industry. And similar to what I've described before, history of revenue generation and hiring can also support that you're well positioned to continue driving forward the endeavor if you have been leading the company up till the present. All right, so let's talk about what sorts of documents are needed to prepare a successful NIW submission. So the important thing to go over is first to provide proof that you meet the EB-2 threshold requirement. And as I mentioned in the previous slides, you can either meet the requirement by showing that you have an advanced degree, master's degree or above, or showing that you have a bachelor's degree in your field and 5 or more years of progressive work experience following your bachelor's degree. Now, if you're meeting the requirement through that particular equivalency analysis, then you need to get letters from your previous employers describing how your roles and responsibilities have changed progressively in the 5 years that you're trying to claim, right? So getting the letters, detailed letters from your previous employers are very important, and they must accompany the petition to prove that you have that 5-year experience. If you are trying to meet the threshold criteria through showing that you have exceptional ability, you do need to provide the evidence of, under 3 out of the 7 enumerated criteria that we described earlier to show exceptional ability, and the universe of evidence that you collect and present must show on balance that you are operating at a level significantly above what is ordinarily encountered in the field. So, a volume of evidence may be needed to support that argument as well. Now, provided that you already have, the supporting evidence for the threshold criteria, the next part to work on is collecting and presenting the evidence that you qualify for the National Interest Waiver by showing evidence under all 3 prongs, substantial merit and national importance, well-positioned, and on balance, that it benefits the United States to exempt you from the labor certification requirement. So there are a variety of types of evidences that could be relevant to all 3 prongs. So news articles, academic papers, market research, those are relevant to the first prong, substantial merit and national importance, describing your field and what is the potential impact of your work and why is it important to the United States. How does this serve U.S. strategic interests? For that, we want to pull reports from, government agencies describing the importance of that particular field, or describing that, advancement in a particular field is needed. If your endeavor is related to a CNET area that we've talked about before, we can also pull the CNET list and highlight that your area of endeavor matches, one of the enumerated critical technologies that the government thinks is important. One thing that entrepreneurs can consider is to include a business plan with the petition to show, to really explain what the business is trying to do, and also to project the potential impact, the potential economic impact of the business in the next 5 years or more. So that comprehensive business plan showing your growth potential, showing your hiring potential, showing your revenue generation potential could be helpful in, in supporting your argument that your work will have a substantial positive economic impact to the United States. Expert letters. Expert letters are a very important part of an NIW petition because it really plays a role of building the narrative of why your work has a wider impact than just benefiting your immediate clients or employers. So basically, the letters can describe, for example, what is the area that is lacking in your particular field, and what can your work do to really improve best practices for the field as a whole. The expert letters can help contextualize the meaning of your work to the field, and that is why it is very important to strategically draft those letters, strategically work with the referees to have the content, include the content that is helpful for your NIW argument. For well-positioned, to support the well-positioned requirement, we would typically include the applicant's resume, all relevant degrees, proof of professional accomplishments in your field, such as any awards won, patents published, presentations that you've done at conferences, any industry or media features about you and your work that really shows that your previous work has had a broad impact in your field already, that can support the claim that your future work will also have a strong impact. And also that you are well positioned to carry forward the endeavor to make a positive influence in your field. So really, it is important to have a volume of evidence showing a past history of successes to prove that you're well positioned to advance your endeavor. Entrepreneurs. So in case of entrepreneurs, one thing that we like to do is including, contracts with representative contracts with leading industry actors in the field that can show that, there is demand and interest for your work in the United States, letters of intent from various partners in your enterprise, such as, letters of intent from, venture capital firms that are interested in investing in your endeavor, for example. Those can be helpful forms of evidence. One thing that is particularly helpful is if you can get a letter of support from a government agency, someone who is with a government agency. It doesn't need to be a congressman, but a letter from a congressperson, for example, describing the impact of your work and why is it important. That can be very helpful in supporting any of the 3 prongs or supporting all 3 prongs. Even if it is a letter from a local government official, in certain cases that could be helpful to, prove national importance, because one of the ways you can meet national importance is to show, for example, if there is an economically depressed area and if your work will really play a huge role in revitalizing that depressed region. That can be one way to support national importance, and a government letter from a local congressperson at the city level or even a regional level could really be helpful to substantiate that claim that your work has that, proportionately high importance to the region's interests.
So Jiyae, we got a question about the expert letters.
Yeah.
Have you seen, does the government actually ask for proof of statements made in the expert letters? So are they going to want to see evidence of what's stated in the letters, or do they usually take those letters at face value?
Yeah, so they usually do not take the letters at face value. So the most powerful forms of evidence is if the narratives written in the letters are corroborated by objective third-party evidence elsewhere in the petition. So, for example, let's say you worked for a company and you helped commercialize a product. And let's say that product, the technology in the product has also been patented, right? So you want to also include a copy of the patent elsewhere in the petition, in addition to the letter from your employer describing your critical role in developing that product. And also maybe you can pull media articles talking about how innovative the product was. If it was widely commercialized, shortlisted in, conferences and things like that as a, innovative product, you want to include evidences of these media articles and references in elsewhere in the petition, third-party evidences to corroborate the statements made in the expert letter. So if you have both, then that is the strongest case. If you're only relying on the narrative in the expert letter, that will unfortunately, the USCIS does not need to believe that. So definitely try to get as much corroborating evidence you can.
Perfect. Thank you.
All right, so we will move on and discuss a case study for entrepreneurs. So let's kind of unpack, how this particular case met all three requirements to qualify for an NIW under the matter of the NSR three-prong criteria. So let's start with substantial merit and national importance. So this applicant in particular was an entrepreneur who proposed to set up a small consulting firm. And what did the consulting firm propose to do? Focused on doing projects with relevant organizations to improve veteran services and care for wounded warriors. And in particular, this person recognized that returning, veterans and wounded warriors were having trouble reintegrating into productive society, getting jobs that they like or things like that. And so they proposed to, design and organize various programmings around this topic to really help engage, those veterans to connect them with productive work opportunities in the United States. So substantial merit and national importance. Now, some of the evidence that this person was able to collect were, media articles, news articles describing this gap in the industry that needed to be filled, describing this lack of, competent services to, returning veterans from Iraq and Afghanistan. And those reports, which included government agency reports, showed the value and importance of providing these services to this population. In addition, the applicant was able to get letters from senior officials, senior leaders in military, government, business, and industry to support the importance of this work and why and the potential impact of the particular business to improving services offered in the United States. With regards to well-positioned, right? So what really helped with the well-positioned argument here is that this person had a very remarkable success record in past endeavors in the UK, where this person was from. And this person was able to get letters from very senior officials in the UK from the government who had worked with him in the past, who provided these very detailed testimonials of what happened with the projects that he led. So intangibly, the scale of the projects that this person has led has resulted in millions of dollars of charitable funding being productively connected with charitable organizations that actually implemented these programs to connect wounded warriors to productive job opportunities, resulting in over 100 of veterans who found new jobs. So those very specific, concrete details of these, of the impact, the real world impact that this person's endeavors have had, really helped prove that he was well positioned to advance the endeavor. Now, on balance, beneficial to the United States to waive the labor certification requirement. There were quite a few arguments that were available to him as an entrepreneur to support that on balance, it was beneficial to approve the NIW in this case. And those included, first of all, as a self-employed entrepreneur, it would have been impractical for this person to get a permanent residency application approved by the traditional labor certification process because he was self-employed. There was no job offer, from a third-party organization. This person was, about to set up his own firm. Additionally, the government noticed the broad value of the work that this person planned to provide, and the unique track record of success in his endeavor in the UK, which proved that he had unique know-how and knowledge and experiences that were not easily replaceable by just another US worker with minimum credentials. So those were important considerations that he could use to support that he merited an NIW. So provided all of these favorable facts, the government was able to conclude that granting the NIW would be in the national interest, and so the application was approved.
All right, great.
Okay.
Well, Jiyae, thank you so much. We have a very active audience, which has sent in some great questions. Feel free to keep sending in some questions. We have a few minutes left, and would be happy to talk through them. I will start by just saying any questions that are unique to your eligibility, your background, we're not going to cover in the webinar. So feel free to schedule a consultation. The webinar, we really do want to cover questions that are more broadly applicable and helpful. So let's start off by addressing this question. What are the pros and cons for someone who's in the US on an F1 visa, a student visa, and is getting a PhD? Are there pros and cons involved there with pursuing an NIW? Are there potential consequences that they should be mindful of? Can you talk about that?
Yeah, so I would say the non-immigrant intent piece is definitely something that is tricky, and careful consideration is recommended before you would file an NIW. Because once you file the NIW, for example, let's say you file the I-140, you could be challenged when you're, applying for a new F1 visa, for example. If you need a new F1 visa stamp, you would go through the consulate, and when you're being interviewed at the consulate, they would be able to see that you have applied for an NIW, and it needs to be disclosed. So that may, depending on your particular case and your particular consulate and the officer, that could be a challenge for you to, continue to, get the F1 visa if you need it. Yeah, there could be arguments that you can use. For example, if you're already in the United States on an F1 status, and if you're applying for an OPT or STEM OPT, having filed the I-140 may, it may not, completely disqualify you from this, but definitely talk to a lawyer first before proceeding. I have seen, anecdotally that it has been possible for some people to get OPT or STEM OPT even after you file the I-140. So it may not be a problem, but definitely good to check all of your, circumstances before proceeding. And yes, you can certainly file the I-140 during your OPT or STEM OPT.
Great. There is a question about applying for an NIW while with a pending asylum case. I will just say that it can be very complicated. Schedule a consultation, but unfortunately, oftentimes it is not possible to do that. But it is worth talking through further if you'd like. So, Jiyae, another kind of thread of questions is about what type of business is eligible for an NIW. And someone asks the question broadly. Another person says, I tried to start a video game company and it was denied. Can you talk about, are there categories of businesses that just don't work for an NIW? And if there are not categories of businesses that don't work, how can you strengthen a business that might not seem to be in the national interest, like say video games?
Yeah, that is difficult because there is a, qualitative impact argument that you need to make, and you need to really persuade the government that your work tends to, advance, some a national priority, right? And there is a argument that you can make for substantial merit if you have, if you are offering an advancement to a particular field as a whole. But for, yeah, things like video games, like, if it's related to things like, for example, gambling, there is really an element of the social impact that you need to, be able to defend. So it could be a more difficult category, right? If you're going with a category of business that does not have an apparent connection to, to the social impact. Another type of cases that could be difficult is, for example, if you're operating a pizza business, for example, like a restaurant, right? A very straightforward business where you're, providing food services. Now, it could be possible to have build an alternate argument for national importance, but just for the type of business, right? You can see that it could be a little bit of a more higher challenge to get approved for the NIW for that type of business, because it is very possible for the USCIS to come back at you and say, well, if you operate a pizza joint, it just means that you will, probably benefit your customers, right? But that is the end of it, right? The business of the impact of your business is local, it's not national enough. Like you're not, providing, a socially, a broader impact to the economy or society, or something that can be tied in more easily to a enumerated national interest, such as, sustainability, or, social justice, or I don't know, a broad cultural benefit, or things like that. There are some categories, I think, of businesses that is just harder to make that link, or maybe it becomes more of a stretch to make that link. So if that is your case, then one alternative way you can try to frame this is really working with a local government to prove that your business will revitalize a economically depressed region, because that is one area that you can use if your business is operating in a particular target employment area, and if you can prove that your business will generate enough employment to really vitalize that region, and if you can support that with objective evidence and letters of support from local government officials, then that is a more favorable case. So I would encourage you to do that if you cannot change the type of your business to a more attractive one for the national importance argument.
Perfect. Regarding evidence, is there a risk? Does the evidence need to refer to the company, or can it refer to the individual? The specific question is, I have a patent, it's filed by my company, but my name is not there. Can you speak to that?
Sure. So you could potentially use that if elsewhere in the petition you can show your personal role, your critical role in having that patent filed. So if you played a critical role in developing that patent, and if you have someone from the company who can testify to that critical role, then you can use a combination of that expert letter and the copy of the patent to showcase that you have worked on a project that has resulted in a patent, and you have played an indispensable and critical role in it. Now, if you've only played a ancillary role or a minor supporting role, then it could be a more difficult case to argue, like, that this is actually your achievement. So it really depends on the facts. But the short answer is, yeah, you may be able to overcome the fact that your name is not on it if you have other forms of evidence that can tie your personal role and personal contributions to that achievement.
Great. Can you talk a little bit about the pathway from an E2 to an NIW? And first of all, is it feasible? The answer is yes. But do you have tips for someone who's looking to navigate that?
Right. Okay. So how feasible it is to change from E2 visa to EB-2 NIW? Yeah, we have processed many cases that went from E2 to NIW. So that's definitely an option you can consider. I would ask questions about what is the offering that your business brings to your industry as a whole, and what is the universe of evidence that can support that. So, for example, I ask clients about this. Have you presented in industry conferences regarding your original approach? Have you, authored any patents? Have you published any patents? Have you authored any papers? Have you been featured in industry podcasts? Have you been interviewed by industry blogs or industry newsletters or things like that? Have you been featured in those kinds of media sources? Like, what kinds of evidence is out there to show that the impact of your business is not limited to just benefiting your clients, but has a broader impact to the industry as a whole. That would be the very important question that I ask clients. And the more evidence you have to support your broader impact, the stronger case you would have for the NIW. So if the NIW is something that you're working towards, then definitely raising your public profile and getting those evidences in place would be a good next step item to prepare for a strong NIW case. And in parallel with that, I would ask you questions about your business performance. So what does your, hiring metrics look like? What does your revenue generation and tax returns look like? And the higher growth that you can show with your historic, financials and your projections, the better case it would be. But I would definitely encourage the entrepreneur to attack both fronts, because you do need to have that broader impact argument in order to succeed for the NIW.
Great. There are a couple of questions that fall along the lines of the issue of dual intent. And the questions are, one is about, I have a B1, B2, I filed the I-140. Am I going to have issues when I try to enter the US on the B1, B2? The other is, can I apply for an EB-2 NIW while I'm on a TN visa? And I'll just quickly say that the risk is there really at any point that you apply to the government for a benefit or you seek entry. So as soon as you file that I-140, you are creating some risk that the government will say that it doesn't believe you're going to leave. It doesn't mean you can't, present your case and say that your consular processing, for example, and you do intend to leave at the end of that visit, but certainly you can get questions and you can be denied entry because of filing an I-140. So Jiyae, a few other questions. Is there a minimum investment amount for an EB-2 NIW?
No, there is no minimum investment amount, and really that is not the concern of the EB-2 NIW. The concern of the EB-2 NIW is really about the potential impact of your business on, the industry, the economy, and they really do not care how much money you invested in it. To qualify for the E2 visa, though, there is that requirement. So definitely make sure that you understand the distinction.
Yeah, and the EB-5 as well.
Right.
And so this is an interesting question. You've submitted a business plan as part of your NIW. To what extent can you stray from the business plan, or is the government going to penalize you in some way if you stray from it?
Yeah, so if you submitted a business plan for your initial I-140, and if you get a request for evidence, right, for that after you get an RFE on the I-140, then there is a risk that the government will think that you're trying to qualify under a different set of facts. And that really calls for a new application, not a response to an RFE. If you already submitted an I-140 and a business plan, you do need to be consistent with what you represented earlier. You can definitely clarify the focus, and you can definitely add more elaboration to your original business plan if that wasn't there before. However, you cannot be inconsistent. Otherwise, you can just go ahead and file a new petition, and your case will be judged by a new set of facts.
Great. We have 3 questions and 1 minute, so let's get through these really quickly. One question is whether AI falls within the STEM guidelines.
That's right.
It probably does.
Mhm.
We can take a closer look if you want to discuss further, but fairly confident it does. Jiyae, could you just very broad strokes the timing? How long does it usually take for a client to get all the information needed and then for us to get an answer from the government?
Right. So I think there are 2 separate questions. How long does it take to prepare an NIW application, and how long does it take to get an answer from the government? So I usually give the estimate of 90 days for the whole document preparation process, preparing the expert letters, getting everything signed, and collecting the relevant documents to compile an NIW petition. So I would say 90 days for preparation. And to get an answer from the government, For the I-140 part, if you use premium processing, that's 45 days. If you get an RFE, then you respond to the RFE, and then there's another 45 days if you use the premium processing. If you don't use the premium processing, then it's about a year with regular processing to get an answer on the I-140. Now, the priority date backlog for most countries around the world is about delayed by about 1 year. So from filing to priority dates being current, we've been seeing a delay of about 1 year. So that's another thing you want to consider. And so after that, you file the I-485 or go through the immigrant visa process, and that would also take about a year. So you can estimate, 1.5, 2 years, 3 years in total. You can do the math, but that's the general timeline that I can give.
Perfect. All right. And it is 1 minute after. So, respecting everyone's time, I want to thank you, Jiyae, and I want to thank the audience for some excellent questions. If you do have follow-up questions, don't hesitate to reach out and schedule a consultation with us. Check out our YouTube channel. We put our full webinars as well as shorter videos up there. And we will be following up with you all with an email with the link to our YouTube channel and a comprehensive NIW guide. We hope to see you on future webinars. And Jiyae, thank you again. Everyone have a great day.
Thank you, Dustin. Thanks, everyone.